Morning, everybody. My name is Bob Bothwell. I'm the interim director here at Health Licensing. Thank you very much for taking time out of your day to come spend it with us this morning. I'm going to call the meeting to order. The Sign Language Interpreters Board Meeting is convening at 10:15 a.m. on January 3, 2024. This meeting is being held in person by Zoom, video conference, and is being recorded. The recording will be posted to the internet for public viewing. The Health Licensing Office asks that individuals attending through Zoom keep your phone muted and cameras off during the entire meeting until you are given an opportunity to comment during the public interested parties feedback period, if indicated on the agenda. I will call a roll. Jack Ludwig. Padre Ramirez Lazenbeck.
Here.
Al Mascarenas. Mish Katek. Colleen Thayer.
Present.
Tammy Adams.
Present.
Eric Cook. Here. Members, when you wish to speak, please state your last name for the record. Board members are also asked not to use the chat feature during the meeting. That's not a worry about it here for a person. Public members wishing to speak must first sign in on the roster sheet available. For public members on Zoom, please email Carrie Edwards at carrie.edwards@oha.oregon.gov and provide your first and last name. Everyone is asked to use appropriate language, manners, and protocols when conducting board business. And I did want to make a note that we're missing one interpreter at this point in time. And so there may or may not be an interpreter on the screen. Okay, so the first thing we need to do, if everybody has had the opportunity to review the agenda, is have a motion made to approve the agenda. And that was Mish. Can we get a second? Eric? Board members, please.
I'm so sorry to interrupt, but some of us are having a hard time hearing
the
definitely
Agenda
speaking.
has been approved, and I will call roll. Jack Ludwig for approval.
Yes.
Padre Ramirez, do I have him back?
Aye.
Al Mascarenas.
Yes.
Mish Katek. Colleen Thayer. Tammy Adams.
Aye.
Eric Cook. Very good. The next item on the agenda is introductions, and since I'm doing the speaking right now, I'll start. Thank you. So again, my name is Bob Bothwell, and I am the interim director and have been for the last year and a half. I've got 30 years with Oregon government and 11 years here at HLO. So this program was given to HLO with passing of 2696, and with a very short timeline, which I think everybody has recognized. And I will say thank you now for your patience with us as we learn and forward. We're very excited to work with this board as a team and learn how to interact and how to support it. The next 2 days, we'll get to know each other and you'll learn about your roles and you'll understand what we do and how we can make this a successful journey. I want to acknowledge a job well done to HLO staff for pulling this off in 6 months and our DOJ team, and they'll introduce themselves later. Currently, I'm just going to put this out here real quick. as of yesterday, and I think the number's already changed, have issued 200 licenses. Okay. It's not just in my head. Next on the list, we Sammy.
Sandy Catwood, I'm a policy analyst for this board as well as several others. I've been with this office for 27 years and run on many boards, brought professions into boards, moved professions into other boards, merged boards, so, but never done anything quite like this. So it's been an interesting journey. I do appreciate everybody's help and patience with us. But let's work with everybody and nice to meet you.
My name is Heather Vogelson. I'm an attorney with the Oregon Department of Justice, and I assist the health licensing office as well as various programs, boards. And I'll be assisting your board as well, and I look forward to working with all of you. Oh, yeah.
Hi, everybody. My name is Travis Shuck. I'm the regulatory manager, so I get all the enforcement issues for the office. I want to welcome the board to our HLO family and look forward to working with everybody. Won't hear a lot from my side today, but in the future, we will get to know each other better.
Good morning, board members. My name is Ally Singh, and I've been with the
For,
state
the fingerprinting of the owners, partners, persons with similar interests is required by bill. If there's a backlog at the Oregon State Police or background check, that's out of our hands, right? But we've talked to folks who've worked with like California, and they're like, oh, they don't even like pick up their phone for
Good
5 minutes,
morning. My name is
Um,
Tina Russell.
it's,
I'm the
you know,
licensing manager. I've been with
probably
this
get things turned
office
around in a few
for
weeks.
27 years. And looking forward to working with all of you.
Yeah, please.
Hello, I'm Jack Ludwig. I'm a representative from OAD, Oregon Association of the Deaf. I'm the president, and I look forward to working with you all. Thank you.
Yes, please.
Hello, I'm Al Mascarenas. I'm a representative with Bridges, Oregon. And it's nice to meet you all, and I'm looking forward to working with you all throughout this process. Okay, a lot of white space, that's okay. I'm Colleen Bayard. I'm not sure exactly what I'm representing. I wear several different hats. I'm deaf. I'm a user. I am also a freelance interpreter. I'm a certified deaf interpreter. Does that cover all the basics? Oh, and I think the last time I counted, I've got about 16 licenses from various states. Hello, my name is Eric Crook. I'm a hearing interpreter. I'm from Southern Oregon. And I'm here to serve on the board. Great, thank you. Hello, my name is Tammy Adams. I'm a hearing interpreter. I've been interpreting for 28 years. I started in educational settings and then I moved into freelance work. I worked for 15 years in educational higher ed, and now I've gone back to being a freelance interpreter, and I'm happy to be here and work with everybody today. Hello, I'm Nish Katek. I'm a representative with ORID. I'm a hearing interpreter and interpreter educator, and I'm looking forward to working with everyone.
Okay, thank you very much. Everybody, it's a pleasure to meet you. And welcome again. Next on the agenda is, I do want to talk about logistics real quick. So there's coffee and water in the back. I think some of you've already seen it. And then straight down the hall before you exit the hallway, on the left is a restroom. Next item on the agenda. Oh, I have one question for the board. I'm sorry. Does the board mind if we use a first name basis? Okay. Okay. All right. So now the next thing on the agenda is overview of the agenda and meeting flow.
Should we let on the read or just say? No. Just say go ahead. It is, I mean, the circle of death, so if you can-
Yeah, you can do it. I need some hammer. Oh, really good. Good job, man. I think they have. Are you in the meeting? No, I'm in. But the audio is. I don't see. I don't. You have second piece versus audio. The audio is not. The audio is not very good.
Oh yeah, no, I agree.
I don't know. It's that's kind of subjective. Honestly, if it's a new word, it probably is. But it's pretty bad. I'm trying to get
How they kind of are.
Am I on? How do I set it up?
Finally received a chat from a man who was with his daughters who saw him on the path walking their dog with a man on a motorcycle around 6:25. The father of the girl who description of the bike. And it said the colors were blue, white, and it was here. At 6.
But how do I present it on Zoom? Do I just like screen share? Is that what that is?
I was
So,
on.
basically, it's a 2-day meeting, this is Sandy.
And two people here.
And now to introduce ourselves, I'm going to go over a PowerPoint briefly, just to kind of get you introduced to each other, where we've been, what makes us up. And then go over 2696 and how HO has implemented the structure of that bill and how
Right now.
we foresee it going forward. And then we will switch over to Heather. She'll give her presentation on member orientation, so public meetings law, going in that executive session, what's okay to talk about, what's not, how to be an effective board member, conflict of interest, rulemaking process, brief meeting, and then we'll break for lunch, and you guys can tell us. I've read online like every hour for a break, but I don't really know if that's true, so. Yeah.
Upstairs?
Just let us know how you want to move forward with that. This is our first time using Zoom, so bear with us. Everything is new in this situation today, so we're working through all kinds of issues. Yeah, no, we're glad to do it. Then I'll do a policy report and then we'll go into executive session, discuss legal advice. And then you guys will go to chair, vice chair. With that, rule to potentially adopt temporarily for extenuating circumstances, and the public will get to on it, 3 minutes each. And then I'm gonna get some feedback from you guys. I'm gonna give you some of the information I received via email since the rules are like that, and then get some feedback from you on how you want to move forward with rules during the permanent process.
How did I get it up there? Trying to get it going. How do I move it up there? We'll just go with this. Okay, go. I don't know. Nope. No, me. It's okay. What's it to these screens? Like, I don't know how to switch it. Swap presenter viewer and slideshow. But I don't know how to split the screen unless I screen share. But then it automatically goes to this.
Right, so she's gonna have to.
We're working on logistics to separate the screen for people online.
I'm gonna have to screen share. And, how do you make it just here?
Well,
See,
yeah, I
come
know,
in
you're gonna have to just stop doing it that way. Here's what I'm gonna do it that way.
this way.
Yeah.
But how do I make it bigger?
I don't think you can. Well, I mean, you can do that, but.
And then screen share. Okay, so that's bigger there.
OHA, we are under OHA as many other programs are. And the basic premise around OHA is how to help the organ, and HLO fits into that mold. We're protecting public safety by making sure that the facilities are clean, that environmental health specialists are doing their job in restaurants, making sure respiratory therapists are, doing things in hospitals that are up to par and standards, and ethics, and all those things. So that's kind of how HLO fits into the mold of OHA. We kind of always say that we're kind of the step shop, is we're down in Salem, and everybody in public health is important. So we're all alone together. But it's always interesting. And so the health authority has, next slide, sorry. There are 7 divisions under the health authority, and we are under public health, which has 4 centers, and we are under the Center for Health Protection. HLO started in 1997. It was the Health Division Licensing Programs, and it was actually under the Public Health Division before there was a long time ago, in 87, and it was made up of 4 different programs: cosmetology, dental technology, hearing aid, and environmental. In 99, we went back to the legislature and they made us our own agency, all by ourselves, under DAS. And then 2015, they stripped us under Health Authority, where we are now. When that happened, we had 14 boards and programs. And then as of 2023, in green on sign language interpreters, board of sign language interpreters, there's 19 programs now. So we, I think every session we brought on a new program since 05. So HLO, next slide. Sorry. So HLO's primary focus, which I already said, is public protection. It's we coordinate, and why HLO works is we do our administrative functions and regulation of all health care professions in the same manner. So we license people, you apply, you take your money, you make sure you meet qualifications, but even though it's a different profession, it's the same process. Same process. We get a complaint in, we investigate it, subject matter expert will look at it, there's a report done, so they're always the same. That's why HLO works, and why you can take different professions and plug and play them in, because at the end of the day, different scopes, but we still do the same job. So that's slide. So we have our own kind of missions and goals. So customer protection, uniform structure. Usually I get ahead of myself in slides. Licensing regulation. We promote effective health policies. So working with OG professions, associations, consumer organizations. We try to be inclusive and transparent as possible and bring everybody's opinion to the forefront so that everyone has a say. We form partnerships in the same manner, improve compliance through education. So when we go out and inspect health ecology systems, body art facilities, inspectors are teaching and educating on new rules or safety and infection procedures, such as going out on site. So we're educating people on that. And then standardized administration and under Trampus is resolve disputes, complaints, settlement agreements. Next slide. HLO has kind of several different boards. I tried putting into 4 different categories. There's variation. So HLO no boards. If there's no board, say music therapy program, HLO oversees that. HLO writes the rules, and it's a program. It's what we call a program. There's the health licensing office consultation with the board. So the advisory council on here, body art. Those are ones that HLO has most of the authority. We must consult with the boards, and they have board functioning board. And then the board has most of the authority. Your board, midwife board, cosmetology, and it's a mix, but mostly the board has the authority, and then there are boards that have dental technology, HLO has the authority, and the board has the authority. They're all different, they come at different times, have a professional one, so it just depends, and we kind of give you all the things that we have, and we kind of. Next slide. So as I already said, we have 19 working programs, 122 board members that serve on the boards with one council, 30 professions, I counted this morning, and you guys, there's 30. In 2024, we have 7 public meetings scheduled, so a lot of meetings in this room. Most of them are done online still, but we are trying to move to in-person meetings as we move forward. Next slide.
Next slide.
We have 33,000 authorization holders, so people who hold licenses, HLO, and we issue about 73,000 licenses. So your group is a great example of for one person to hold multiple licenses. So that's why that number varies. Cosmetology is the same. If you're a nail technician, you've got one. If you're a hairdresser, you have 2. So that's what happens. That number's changed. There's actually 22,000 business authorizations. No, I'm sorry, 13,000. This little one. And that's between cosmetology and body art, and the cosmetology are also independent contractors, so they're like a mini facility in a facility. So they do their own taxes and all of those things. Regulatory, so in Travis's group, about per biennium, about 1,700 formal actions written, and there are about 22,000 inspections every biennium, and that varies depending on next one, depending on number of inspections, up to 5, but right now. So that concludes my presentation. If you have any questions? Here to answer them.
Don't get any questions.
Nope. I will eventually. Oh, 26 minutes. So everybody knows that we got the bill. The offer date of the bill was January 1st, and if you don't know, I'm sure everybody knows this by now. There's people who-
I haven't been able to let him in because I've been presenting. Why is Sammy joining? Everybody's admitted, yeah.
Sammy again, and just to give a brief overview of House Bill 2696 and bringing it into HLO. When we got the bill, start licensing, having interpreters, on further review, we figured out that the board can't do their job until January 1st. Everybody has to be licensed by January 1st, and we'll see. So, so HLO does have some authorities under their own statutes, so it's some broad authorities. So HLO went ahead and did rules so that people have opportunity to get licensed and we need community services in Oregon for people that need them. And then with that, we so you don't have necessarily have to obtain a license until June 8th. Because it's a waiver. We are, HLO can use some discretion on providing municipal penalties and things like that, and this time we're not going to do that for signing. But
Just jump in.
yes, please jump in.
This is Heather. I'm just gonna clarify that point because it's a little nuanced. So the law requires people to be licensed by June 21st. And under the bill as well, HLO has discretion in terms of whether it would, what discipline it will impose. So in terms of just HLO and what HLO can do, HLO has authorized a very small, limited waiver of enforcement for people who provide sign language interpreter services without a license. That wouldn't cover other things, including discipline that HLO does not have authority over. So it's a little bit nuanced, but just wanted to make that clear that the law does require people to be licensed. Yes, that's the first. And one of the ways that HLO is helping the profession get on board is having that limited waiver if you are providing services without license in that very narrow circumstance. It would not impose discipline.
Well said by the attorney. Appreciate it. So that's kind of where we are. I'll go into more detail later under reading the rule process, but briefly, so the board meeting today, if you guys are going to give me some direction, like I said earlier, on how the rules go, what I should present, the measure committee, those types of things. There, I have 2 rules that I previously scheduled for the 15th and the 20th of February. So, these are the last one of those. So, just put the application in the large box and everything is ready. Then, to meet that June 8th timeline, we will file rules for Secretary of State, and that will go back with 1 year of public comment period. Everybody will have time to comment on this. So we'll take all that feedback in, there'll be a hearing, also the hearing process, if people can with their verbal testimony, they can come over Zoom, table, and then I will provide all that information. The recordings, hearings, the rules, advisory committee recordings, you'll get everything. And then you guys will deliberate and you just have to consider all the comments that are, it doesn't necessarily mean you have to go with what they request, you just have to consider. And then rules will be in place for June. That's the plan going forward. Of course, it's flexible and we can always pivot faster. So we're just looking forward to getting moving. You said that the
This is the second page for the rules advisory committee. February 15th, and what was the other one?
So rules advisory committee, basically what happens is the board is going to tell me later what communities and persons that would likely be affected by the rules that you want to serve on the committee. We give you that list of the types of people, whoever you guys decide. And then I take that away and I send out a letter, outreach to different communities, we have a list of people. Sometimes they're specialized, sometimes they're more generic, but being gone, go down that path. Usually 10 to 12 rules advisory committee members. It just kind of depends on how many community people are on it. that, it just really depends, but those two dates, maybe only one, but scheduled for two. In 4 members usually do not serve on the rules of advisory, because you make the final decision. So you approve the proposed rule that applies to the state, and then you would actually adopt the final. So you need to decide to deliberate on all the comments that we get. But we have had somebody, like, sometimes we have one board member serve just for continuity to like carry the message of the board, so that's not unheard of.
Any other questions?
So we have that limited waiver until June 8th for enforcement, but the law clearly says the HLO only. So I'm wondering, can there be other authorities that require licensure that could sue or file grievance that supersede HLO's authority? I'll take that one.
This is Heather. That's a great question. So under the law, HMO has disciplinary authority in terms of regulation of licenses. Under the law, there's also a criminal penalty for providing sign language services without a license. HLO does not have authority over the criminal stuff, so that's not what it does. So that would be a different entity. We don't have control over what they do. HLO has authority over its regulatory jurisdiction and has made that decision to exercise its discretion so that people who do not have a license to provide sign language interpretation services would not be disciplined through HLO for that particular violation until the end of the waiver. Any other questions? So we can we'll just move on to the next item on the agenda. Trampus was here, he introduced himself right here, Trampus Chef. He is the interim manager for regulatory. Investigation. T-R-A-M-P-U-S. That's correct, T-R-A-M-P-U-S is his first name and Chef is his last name. Does anyone need a break? Okay. So it sounds like we'll move forward and I am the next person to present. My name is Heather and we are going to do a board member orientation and training. I'll give Carrie a moment to bring it up on the screen. I do have a PowerPoint and then I'll be filling in with words that PowerPoint. So as I mentioned, my name is Heather Ogleson. I'm an attorney with the Oregon Department of Justice. I've been there since 2005. I've worked with HLO since about 2015 or 2016, and it's been a great journey. I'm really excited to work with your board. And welcome to government, because there's a lot to know, and that's what this presentation is going to focus on, is some of those things that you need to know to be an effective board member and to keep us all on the straight and narrow. Okay, so we will move to the next slide. We are going to talk about public meetings, which is what we are in right now. And there are certain requirements that govern those public meetings because you're now a part of government. So we'll go over that, including executive sessions. We'll talk about how to be an effective board member, things that you want to know. It's important to know these things so that, again, you can do your jobs effectively. We're going to talk about the conflicts of interest and those types of issues. Not necessarily conflicts of interest, ethically speaking, but kind of bring that to mind. And then we're going to touch on the rulemaking process. So the next slide. What is a public meeting? The law defines a public meeting as when a governing body is convened for which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. It's a law of transparency, and it allows the public to know what the government is doing. There are limited exceptions, but the law does give us certain exceptions as to when a public meeting or the public meetings law does not apply. If an exception does not apply, then you have to follow certain requirements. In 2013, there was a House bill that passed that said that serial electronic written communications is also now a public meeting. So a public meeting is just not here, all of us meeting in person, but it can also mean written serial electronic communications, email communications. When a quorum happens and when board business is being discussed. So we're going to talk about this and put this in context so you have a bit more understanding about that. Oh, it also said when an intermediary is used to communicate. So if you're deliberating board business between a quorum through an intermediary, public meetings law would also apply. Okay, next slide. First thing to know, your board meetings must comply with the public meetings law. And that's what we're in right now. It's important to know that the public meeting law applies, that you do not have a meeting without fulfilling the requirements of the law. Again, it applies when there's a quorum and when you're discussing board business. So you have those two pieces. That should ring in your mind whenever you start discussing board business or whenever you see board members that would need a quorum, be very aware. We'll move to the next slide. So what are the basic requirements for conducting a public meeting? The law clearly sets forth that you need to give notice of the meeting. Notice would include the date, time, location, accessibility information, a list of the principal subjects, such as what you have on your agenda, so that the public knows what it is that you're going to be discussing and whether or not they are interested in it and want to attend. You have to be giving access to the public. And that's an interesting one. The public does have to be allowed to attend your meetings, but they don't necessarily have to be allowed to participate. So usually what will happen is there will be a time on the agenda for comments, such as you'll see on your agenda, it says the public interested parties comment feedback period. That's done as a courtesy. It's not required under the law. Again, it's not a public participation law, it's a transparency law so that they can observe, they can attend. It's also not required to respond to public comments. So when public comments come in, there's no requirement that the board respond to those public comments at the time that they come in or at a later time. It's just that you are giving that opportunity for the public to comment and give you their feedback. The third one is access by persons with disabilities. That's an important one. The law says that our meetings must be accessible to all people. There's a requirement that there is a recording or minutes are taken of the meeting. So you'll notice with our meetings that we are taking a recording. Even in executive sessions, there will be a recording that is happening. That's very important so that the public again knows what's going on and can see after the fact, after the meeting, after the fact, what happened. That's something that you'll just have in the background, really not something to notice, except that know that you are being recorded, so you'll want to address yourselves in a way that's representative of the board and HLO, as Bob had mentioned at the beginning of the meeting. You'll also want to announce your name so that the people know who it is that is talking, and so that when the recording is heard, people know which board member was speaking. The last requirement is that official actions are done in public. So final decisions, voting, all of that has to be done in the public. It can't be done in an executive session or a non-public session, and that again, it is for transparency. Next slide. So the law says that your board business needs to be done in the public meeting. And then the law also says that there are certain types of things that qualify for what's called an executive session. An executive session is a meeting of the governing body that is closed to the public. There are only the enumerated permissible reasons for closing a meeting. Otherwise, it has to be done in the public. So unless you fall into one of those enumerated reasons, you have to have the public meeting. Next slide. There are certain requirements that govern executive sessions as well. One, the authority for the executive session must be announced before going into the executive session. The discussion in the executive session has to stay on topic. It can only fall into that narrow exception for why you're in that non-public aspect of the meeting. And why is that? Again, because this is a law of transparency. And the law has said, if you are talking about this topic, you can be in the executive session. If you go outside of that topic, then you need to be in the public session. So it's very important to know why we're in executive session, so you know what you can and cannot discuss, and that you are not off the track, and that doing something that should be in the public portion of the meeting. And again, then no final action or making the final decision can be made in an executive session. Board deliberations happen in executive session for a variety of topics, but then any decision that needs to be made we would come out into the public portion of the meeting, and that is where you would make your final decision. So the reasons that you might go into executive session are to discuss information that HLO obtained as part of an investigation. There's a particular area of the law that says that that type of information is not disclosable to the public unless certain requirements are met. And so therefore you would enter into that executive session, learn about that information, have a deliberation, and then if a decision had to be made, you come back into the public session to make a decision. Another reason why you might go into executive session is for legal advice. And you'll see that later on your agenda, that there is a session today for legal advice. Legal advice under the law is privileged. It's communications between your attorney and between the client, which is you and HLO. That type of privileged information does not get released to the public, and therefore we hold it in an executive session. Executive sessions are confidential. The information that happens in executive sessions is protected. If you receive information in advance of an executive session, such as an HLO sends you documents that will be discussed in an executive session, you want to hold those in confidence. You won't want to have them sitting out on a printer or out on a desk where people might walk by. You want to hold them in confidence so that that information is only available to the board members and the people who are part of the executive session. Similarly, when traveling, you want to be aware that you're keeping that information confidential if you're reviewing any executive session type information prior to the board meeting. You won't want to chit chat about confidential information with friends or with family. Again, that information from the executive session should be considered to be contained within the room that we're in for that executive session, and what happens in executive session should stay in executive session. Same with attorney-client privileged information and any other information that's shared in executive session. Again, the final action is not confidential, and that's why that happens in the public session, so that there's that transparency and the public can know what your final decision is. But otherwise, executive session information you should hold in your mind in a separate place and consider that confidential. There's also something called a non-public session. These feel a lot like executive sessions, but they're not actually part of the public meeting. They are excluded from the public meeting and its requirements, but there are still some requirements that apply. You still must stay within the scope of the reason for the non-public session, and you can't go outside of that. Otherwise, you would be in violation of the public meetings law. You still must wait to vote until you're in public session, so any final decision would need to be in public. It's just a little oddity. Feels like an executive session, but just something to know about. A lot of these requirements for public meetings, executive sessions, and non-public sessions, you'll want to know about, but the logistics will actually be handled by HLO in advance. As you see today, you have an agenda. It meets the requirements of the law, and in terms of it was given notice, it had the location, it had the time, the information that the public needed to know. So you'll see also later on the agenda, there's reasons for the executive session. When we go into executive session, HLO will handle the logistics for getting you in and out. And those types of things are handled by HLO, but again, it's important for you to know when the public meetings law applies, so that when you're outside of this forum, you can be aware of whether you have a quorum of members and whether you're discussing board business, and so that you would know that that would be a public meeting, and therefore you should not be doing that. Next slide is basically what I just said. So no board meetings in violation of the public meetings law. Be aware, you'll see on the left side when you have quorum plus board business. Also email meetings, be aware of that, whether you're responding all to an email. Therefore, there would be a quorum of board members, and if it's about board business, that is something that could be a public meeting. And if notice has not been given, if there's not access by the public, access by persons with disabilities, if there's not a recording or minutes are not taken, then you would be not in compliance with the public meetings law. So again, just hold those in your mind. Okay. Now we're going to move on to records. This also falls under how to be an effective board member. And this is also an FYI to you, so that you know that as part of government, there are requirements that apply to government records called public records. So the public records law says that any writing which contains information related to the conduct of the public's business that is prepared, owned, used, or retained by a public body such as board, regardless of its physical form or characteristics, is a public record. So even sometimes something that is not on a piece of paper, such as it's a voicemail, could be a public record. And you'll want to know that this is, again, very similar to the public meetings aspect. It's a law of transparency. It's a law that allows the disclosure of certain public records when a person requests those records. Now, that's not to say that all public records are released to the public. There are certain exceptions that apply, and if there is a public records request that comes into HLO for public records, those exceptions would be analyzed to determine whether the records fall into an exception or whether they need to be released. We're not going to go through the very many numerous exceptions because that's not something you need to worry about, something that HLO would handle logistically, but you do need to know that when you are communicating in writing about board business, that you may be creating a public record and that there are requirements for those public records. Also, please remember that a public record isn't necessarily just that on which is on paper. It would be an email, it could be a text message, and as you likely know from various things that have happened in the media, Even when you have a text message on your personal phone or your personal computer, if it is a public record, getting into your personal phones and your personal computers might need to happen in order to comply with public records law. So be very, very careful when you're communicating about board business, and know that public records law may apply and that you may be creating a public record. Public records should be held by HLO. Okay, so then we're going to move on. How to be an effective board member. Don't speak or act on behalf of the board unless specifically HLO and/or board approved. Underneath that, there is a quote from your laws that says, there's established within the Health Licensing Office, the State Board of Sign Language Interpreters. A majority of the members constitutes a quorum of the for the transaction of business. Why that's important is because you are a board. Board business is decided by the board, and it's decided by the vote that the board takes. So one individual person cannot speak on behalf of the board because those decisions are made by the board at board meetings. Instead, if you, let me rephrase that. So if you get a question and are being asked to speak on behalf of the board, a way to handle that is to have them contact HLO so that it can be put on a meeting agenda, and then the board could discuss it in a public meeting. And let that person know that you may be responding to that person in your own individual capacity, because you can't have your own individual thoughts and perspectives, opinions and voices. But you would want to differentiate that, and that you're not speaking on behalf of the board and you're not speaking as a board member, you're speaking on your own behalf. That also applies if you're speaking in front of the legislature, which is something you can do in your own individual capacity. You again would just want to differentiate that you're not speaking on behalf of the board. Okay, how to be an effective board member is to act in the public's interest. Sammy went over that as you are under HLO's laws, and HLO, its goal, its focus, its primary responsibility is to be centered on public's interest and public protection. So as board members, that is also your goal, is to act in the public interest. So remember that whenever you are engaged in board business, if you're writing rules or otherwise exercising your authority as a board member, that your interest is to act in the public's interest, and it's not about professional protectionism or your own bottom line, or it always has to be about what is best for the public. So the next slide is just an FYI. Oh, there's a question. Yes, switch. Thank you. Okay, so this next slide has the name of the case. And this case was a decision by the United States Supreme Court, and it decided a federal trade commission case in which it found that a board, similar to what you would have here, where there's board members, they're talking about board business, they're exercising their authority. It found that that board in North Carolina was furthering the private interests of the group by inhibiting competition out in the field. And it found that that was a violation. And so when I say that your role is to be focused on the public interest, I just want to have this as a footnote, is that there is underlying reasons and law and challenges that could come about if you are not focused on the public interest when you're doing your board actions. So very important. Rules, discipline, policy, all those decisions as a board member need to be based on the public. So the next slide is just a reminder of that. Your job is public protection, not professional protectionism. Think of it in terms of wearing two hats. When you're acting as a board member with your board hat on, keep in mind that you're here for public protection. not your bottom line. Do not engage in conversations in the board meetings about protecting your profession or restricting competition. When you do not have your board member hat on, when you're not making decisions with the board as part of board business, then that is a separate hat, that is your own accord. Okay, we'll move on to the next slide. Again, how to be an effective board member. We're going to talk about conflict of interest types of issues, things that may arise and that you would want to know about because there are certain steps you need to take as a board member if there are conflicts of interest. So conflicts of interest are within the Oregon law described as ethics. You may already have received training about the ethics laws here in Oregon. That's a separate training. It goes in detail, I believe, on quite a variety of things. And we're just going to touch on a few things, very minimal here. The law itself on ethics talks about gifts. It talks about using your position for financial gain or to avoid financial detriment. But we're not going to go into all of that because you have that ethics training available to you in a different form. So under the ethics laws, who is covered? Well, public officials are covered. And who is a public official? It's any person who's serving the state of Oregon or any of its political subdivisions or any other public body as an elected official, appointed official, employee, agent, or otherwise, irrespective of whether the person is compensated for the service. So basically, you are a public official. So a good resource for you, if you have questions about ethics, is to contact the Oregon Government Ethics Commission at their phone number. They can also be contacted via email, and their staff is available to assist you with your own personal ethics questions and any situations that you might have. So now that we have that out of the way, we'll talk a little bit about the conflicts of interest. So conflicts of interest are an ethics law, but why it's important for you is because it does interact in your ability to be an effective board member. So there are two different types of conflicts of interest under the law. There's the actual conflict of interest and the potential conflict of interest. An actual conflict of interest is any action, decision, or recommendation by a person acting in the capacity as a public official, which you are, that would result in a private financial benefit or detriment to the public official, the public official's relative, or any business with which the public official or relative is associated. That the financial effect of the action, the official action that has the private economic impact, that it would occur with certainty. Now, the potential conflict of interest is similar, has a lot of those same basic words written into the law. The difference is that it could result in that financial benefit or detriment. So the financial effect of the action, the official action, it would be uncertain. So it's certainty or uncertainty. And again, this is about economic benefit and detriment. It's not just about the people that you know in the community. We'll get into that in a minute, but this is really focused on economics. Okay, next slide. So for determining the conflict of interest, here are some questions that you would want to go through in your mind before you contact the Government Ethics Commission or while you're contacting the Government Commission. To determine whether a conflict exists, you would ask, can the result of my official action, decision, or recommendation financially affect myself, a relative, or a business with which either are associated? If the answer is yes, then you need to ask whether any exceptions apply. And that's the question for the Government Ethics Commission. We're not going to go into those various exceptions because they can be nuanced, and that's when you're in a situation that you really want to reach out to them to get some consultation on. If the answer to that question is no, that the exceptions do not apply, Then you need to determine whether you're met with an actual or potential conflict of interest. Again, going back to whether would or could it occur. If it would occur with certainty, then you have the actual conflict of interest. If it could, and it's uncertain that it might occur, then you're in the potential conflict. Now, why you need to know whether it's actual or potential is that different requirements apply depending on which area you're in. So actual and potential conflicts both require that on each occasion before taking action on the matter, before you engage in that official action, that you make a public announcement that there is an actual or potential conflict of interest. If there is an actual conflict of interest, then the additional requirement applies that you need to refrain from participating in discussion, debate, and voting on that issue in which the actual conflict arises. Now, of course, as with all laws, there are exceptions. So there's an exception there too, that unless a quorum is needed to take an official action, then you need to vote. So that's a situation we would want to discuss in advance. But you will want to know basically, in order to be an effective board member, that these requirements apply, because if you have an actual or potential conflict of interest, you need to let HLO know. And then that way you can get on the record your announcement and follow the requirements under the law for meeting what you need to do for that actual or potential conflict of interest. The next slide, we're just going to hit on, question.
Are you allowed to ask questions or do you want to?
You can ask the question and we'll see about the answer.
So a question related to conflict of interest and financial gain. So there are several of us who are required to have licensure who are on this board. And so that is a direct conflict of interest because I'm paying for my own license, but I'm a part of this board. So I'm wondering if that's a direct conflict of interest. I will be paying for the, voting for the fee structure, but I also have to obtain this license myself. And then Colleen is saying, I have the same question. Yes, Audrey, I had the same thought. At the same time, have you thought about, public benefit as well? How it's, because we have the right to, we have the authority to make these decisions that will affect our industry and affect our colleagues. And so what if a license doesn't get approved? I've been on the board, it's impacting us, it's impacting the people that we work with and the public. And so I do have a question about that as well.
This is Heather. Great questions. And I love that you're thinking about this and asking questions because it actually shows that I haven't put you to sleep. So that's a great question. And that has come up not just for you, but for other board members as well. So there is an exception, one of those exceptions that we have in the law, that would apply to you as a board member for having a license. If you're required by the law to have a license, then that would be an exception. It would not be considered the detriment or a financial gain because the bill that passed required you to have a license to be on this board. Now, that type of question is a great question to take to the Ethics Commission, and then they can talk with you through what that exception means and where some things might lie outside of that exception, such as, hypothetically speaking, there might be a situation in which the board would be deciding, let's say, curriculum. Maybe not this board, maybe a different board. And perhaps there's a board member who has written a book that is considered for part of that curriculum. So would that board member be getting money because that book is being used by students to fulfill the curriculum? So that is something that board member should talk to the Ethics Commission about, figure that out, because it looks like there is that personal financial gain or personal financial detriment that may occur. And then determine with the Ethics Commission whether it's an actual or potential conflict of interest and what needs to be done about it. So there's a little bit of a difference there, but as a board member, just holding a license is not an actual or potential conflict. Does that make sense?
Clarify.
This is Audrey again. Just to clarify, would we want to, if we're voting on something and we decide it's an exception, because there is a financial detriment on establishing this fee structure for me as a licensed interpreter, would that be something we need to disclose like explicitly in the meetings, like that there's an exception for me to be able to vote?
So again, that's a wonderful question. This is Heather. And it's great that you're thinking about those types of issues and the types of issues that you're going to be voting on. So several thoughts come to mind is that one, HLO sets the fee structure. You may need to vote on it, but I believe HLO sets that. They don't even vote on it. So there you go. That's not in your hands. But if you have a situation where it's gray like that and you have a question and it's just like, oh gosh, what do I do? Especially as new board members, really reach out to the Ethics Commission so that they can help you through that and make you feel comfortable. Because we want you to have confidence and feel comfortable in the board meetings doing what you need to do. Yeah. Great questions. Okay. So just along with that, we'll just touch on, one of those ethical issues that you can get more information on from the ethics training is that you can't use your position for financial benefit or to avoid financial detriment. And again, that's one of those issues, as I was just mentioning, with curriculum and the book situation. And that requirement applies to your relatives, members of your household, and businesses that you or others are associated with. So it's a pretty broad requirement. And so just as you're doing right now, you're thinking through these types of issues and go and get that guidance from the Ethics Commission. And I will mention that it is a personal obligation on the part of a board member to comply with the ethics laws. And so that's why we direct you to the Ethics Commission, is because it's your personal responsibility.
You actually will vote on those fees. HLO scoops them into your rules, but they're established by HLO just for logistics, so they're in your rules with your application requirements. So you will vote on them, but HLO actually sets the structure in the fees.
And if that causes you any concern at all, you could ask the Ethics Commission, and if you needed to, you could make an announcement at the public meeting.
So, yeah, can you clarify that? Yes, so HLO sets all of the fees for all the boards and programs, but because there's 20 different sets, we take all the fees for each specific board and we put it in your rules so that you know what you'll be paying as a group of licensees. Otherwise, it would be in like HLO rules and it'll be a giant list. So it's just logistics. HLO approves them, it comes through OHA and public health, legislature adopts them. We actually don't even have to say, the legislature does. So on what the fees will be. It's just in your rule for logistics. Well, I mean, you vote on rules as a package usually. You can vote separately. But yes, you do end up voting for all of them together. I mean, they can go into HLO rules. Doesn't really, I don't think it makes a difference. What was that? I said, I suppose we could consider looking at putting them in HLO rules
I don't know if that would be work, but we could look at it. It's that much information.
So this is Heather. Are there any questions?
And I'll clarify while someone is coming up for a question. There are a variety of,
And we have our interpreters slot, so.
I wanted to clarify a concern. I guess we're mostly wondering how the fees are established. Are we voting to approve or not approve, right? But we have no influence on the amount. But we do have to vote, and so that feels a little bit in conflict. You know, why would we even vote in the first place if we can't change the fee structure? You know, and it will look to the public like we have made this decision, but in reality, we didn't have any authority. And so, again, I think it's an interesting thing. You know, we also have no information on how the fees were made, what they are until just now, and so. Does the profession influence the fee structure or does it not? So I think we just have a lot of questions about fees in general, and it would be nice if we could have some time on the agenda, perhaps not at this meeting, but at a later time, to better understand the fee structure.
this is Heather, and I'm sure Sammy will want to jump in too. So we'll talk a little bit about rules and authority and board statutes a little bit further in the presentation, I believe, so that you have a little bit more understanding. There are, as you know, a variety of different statutes, and then under those statutes, you make rules. So I think what Sammy was referring to is that the sign language interpreters have their own like set location of rules. And so HLO has put fees into that set of rules for other boards and programs. So it's easy for licensees and the public to know what place to find those, even though the authority for them or the background as to how they're established could be put in a different location. But the way that it has been done with other programs is that when the board votes on the package of the rules, they're all put in one location. Other thoughts that came to my mind are that I believe there is a place on the agenda to talk about fees, and that is going to be under number 6, fee schedule. So you will get some more information, and you'll also be able to have more of a conversation then as to what information you need, and even talk to HLO about what your preferences would or would not be for the location of where those particular fee rules sit. A vote today would not be on fees. A vote would come later in the rulemaking process, and so there's not going to be a vote today on fees until later. So there's just a few things that came to my mind as I was hearing those concerns. I'm glad you're expressing those, that HLO has those, and we can address concerns. Is there anything at this particular moment that would be helpful to address before we go on? Okay. And interpreters. Okay, I know it's getting long. We're kind of getting down to the end. If you need a break, let me know. Okay, we're still on how to be an effective board member. So again, this is government. You come into it on the first day. There's a lot expected of you, a lot for you to know. But please know that we understand that this is all new to you and you're hearing it for the first time. And so we're happy to help you through it. And at each board meeting, if you need reminders or if you have questions, happy to help with that. Sammy all of HLO staff are very familiar with public meetings and can help you through it, and I'm always happy to help too. Okay, so we'll be on the next slide of how to be an effective board member. Remember to not use confidential information that you receive for your own private gain. That confidential information that you learn in executive sessions is so that you can do your board duties as board members. Also, do not solicit or receive a promise of future employment for taking an official action. We throw that one in there. It's covered under the ethics law, but it's always nice just to have that repeated. So, okay. So in terms, we'll go down to 2 slides down. And next one. Up one, maybe another one. Oh yeah, that's where we were. Okay, now we'll go to the next one. Okay, there we are. So how to be an effective board member. So remember to consider when you're taking official actions, whether you should be involved in a matter and whether there's a requirement to take a particular action. So that arises with potential or actual conflicts of interest. Also, when you're a fact witness in a contested case. Now, we are not going to go into the contested case process because we would be really, really tired if we did that. That is a lot of information. But just know that when there is a complaint and a disciplinary process and an investigation, if you are a fact witness, meaning you have seen, observed something firsthand, that we would not want you to participate in that matter because you might be a witness and called as a witness. You would have additional information that other board members would not. So in that type of situation, we would have you tell HLO, hey, I know some information. I think I have a concern here. And then we talk through that as to whether you should or should not be involved in that investigation and that information, that decision. Also, under the law, if you're biased or incapable of rendering a fair judgment, then that's a type of situation also where you would want to let us know, because we would want to make sure that you're not involved in that decision-making process. And that comes down to due process under the Constitution, and we afford all of our licensees due process of law, making sure that they are getting a fair judgment. I do think that I understand that you have a relatively small community, and so you know a lot of people in your community. And so you may feel at some point in time that, oh my gosh, I know that person, or I've heard something, and how does that impact me in this situation? So please know that it's not necessarily that you know someone, but it's whether you have that potential or actual conflict of interest where it affects you financially, or it's where you're an actual fact witness, you saw something, you heard something firsthand, not necessarily through a third party, although we still want to know that. But those types of situations where you're a fact witness, or where you've been so biased by something that you can't render a fair judgment. And those are conversations that we would have. So you bring that information to HLO, have that conversation and make that decision whether you should participate. So it's not just whether you know someone in the community. And please also know this comes up for other board members. There's other boards that have small fields as well. So not just you. Okay, so now we are going to hit on the rulemaking process. And we're just going to touch on this so that you have a sense of what the process looks like and why there are temporary rules, why there are permanent rules, and just have a little bit of background for some of the decisions that you'll be making today and tomorrow. Okay, so the rulemaking process, we're going to start at the top, which is the statutes. And so we'll go one slide up. What are statutes? Statutes are the Oregon Revised Statutes, or they're called ORSs, and they're the laws that the legislature has created. Those laws are set by other people, not by us, the legislative branch, but those laws then dictate what the board can do in rule and what authority it has versus what authority HLO has. So that's why we start at the top, because we always have to be in line and guided by our statutes. So we'll go to the next slide. So what are rules? I've heard the word statutes, I've heard the word rules. What are these things? So rules are laws that are promulgated, which are created by agencies. Agencies such as HLO and your board is considered part of the agency, part of the administrative branch, is what creates the rules. So you have the legislature creating the statutes, and you have boards and agencies creating rules, which fill in the gaps of what's in statute. An agency's power or a board's power to create rules is grounded in the statutes. Boards and agencies cannot do anything that is prohibited by statute or that the statute does not allow. Next slide. Great question.
I'm not sure if I'm saying it right, so interpreter, let me know if you need clarification. Based on what you shared about the rules and statutes and the legislature, that there are certain situations where a colleague who could apply for licensure could be denied for any reason, and we would just have to focus on a case-by-case basis. So if I know someone who's already experienced and expressed frustrations at being denied a licensure, we know who that is, I want to figure out how the board can be involved with that case-by-case basis, or is it more of a black and white scripted scenario by HLO? Did you get that, interpreter? Need any clarification?
This is Heather. That's a great question. Thank you for raising it. So I think I understand your question as to where does the board get involved in making decisions about who doesn't receive a license? Okay, so this comes down to what the legislature has established in the bill. The legislature passed 2696 and gave authority to the board for certain things and gave authority to HLO for certain things. And the board has the authority to set what the licensing standards are. But then it's HLO who carries out that process and looks at those applications and says whether or not those standards are met. So it's like a two-piece process. So the board sets standards, and then when a person applies under those standards, HLO looks at that application and says whether the person has or has not met the standard. Now, the denial of a licensure and whether or not you get involved in that, that does not usually come back to the board, a denial of license. I need to look a little bit closer at the bill as to, and there may be circumstances where the board would provide some information, but normally the process is that the board decides the standard for licensure, and then HLO looks at those standards and the application and marries them up to see whether the person has met those standards. Now, does that answer your question? So Bob has mentioned that there is a contested case process for a denial of a license. And that is something we want to get into in a different situation, and lots of information there. But I think the thing that was coming to my mind is that you may be also wondering about these rules that HLO has put in place, setting what licensure is versus what the board is going to set for licensure. I'm not sure if that was part of the question or the concern. If to the extent it is,
I'll hold my thoughts and questions.
okay, great. Because there will be time on the agenda to talk about HLO's rules and the standards and feedback. So, great questions. So glad you guys are engaged. Okay, so administrative rules. They have the same powers as statutes. They are laws that govern standards, licensees, discipline, ethics. They have the same power as statutes. Licensees must follow the rules. And these are used when the agency interprets a statute, creates procedures, or establishes a policy under the statutes. So now that you know that there is the power to create these rules, how does that look? What is that process? So we're going to just touch on at a very high level what that process is. It can be a lengthy process for permanent rulemaking. So the rulemaking process in a nutshell is that there is a process for receiving advice and recommendations through what is called a RAC, a Rules Advisory Committee. A Rules Advisory Committee provides their insight, their intelligence, their background, their experience, their expertise to provide recommendations that are then drafted into rules. Those rules normally are drafted by HLO. The RAC may have a chance to, they may meet several times, they may meet one time, but they would look at those draft rules and pick them apart and try to improve them. Then those rules, it depends on the process, but sometimes they're brought back to the board in a draft form. Sometimes they are just filed with the Secretary of State. But it's a process. It's a process of gathering information, drafting rules, trying to improve the rules. Once the rules are in a good enough draft form that HLO and the board would feel comfortable filing them and sending them out to the public, then HLO files those with the Secretary of State. And that's when notice is given to the public and interested parties that there are these potential rules coming down the line. At that point in time, after they are filed, then the public has the opportunity to comment on those rules. They can provide written comment. HLO usually holds a community date where people come and give their public comments verbally or in writing. All of those comments are collected, built together, and then the draft rules and all of those comments are provided to the board and to the HLO, if it's HLO who adopts the rules, for consideration. The board looks at that information and then makes a decision as to whether to make changes based on those comments or whether to not make changes based on those comments, and puts that final version of the rules together. Once that final version of the rules is ready, the board votes on it, and then those final rules are filed with the Secretary of State. And that's when they become actual permanent rules, and that's when they become governing laws. So there's quite a process. The rulemaking process wants to invite the public comment. It wants to allow the public to be engaged. And so that's why there's the opportunity for a RAC Rules Advisory Committee, community engagement, and also just public comment where people can email, people can leave a voicemail, people can come in and make a comment. And then there is that requirement that all of those comments be considered by the board. So again, it can be a lengthy process, and there's timelines for each of that are built in. There's a timeline for giving public comment. There's a timeline for when how long the notice has to be out there for, different things like that govern. So that's for the permanent rulemaking process. There's something called a temporary rule. And a temporary rule is a little bit different because it doesn't go through this more formal rulemaking process and is only authorized in certain situations. And that temporary rule comes into place where the rules are submitted to the Secretary of State, and that public comment period does not necessarily happen before that temporary rule. And again, there are certain circumstances in which that can happen, and when those requirements under the law are met, then a temporary rule can be put in place. Those situations are more limited because, again, the law wants us to go through this public comment process to get to permanent rules. So why this is important to know, and what you want to know for your agenda today and tomorrow, is that HLO went through the temporary rulemaking process in order to get rules in place for January 1st, 2024, when people were required to be licensed under the law. Now that the board has the opportunity to meet, and we're doing so today as early in January as we could get people together, we now have that opportunity to go through the permanent rulemaking process and have that opportunity for public comment, get people involved, have a RAC, take the comments into consideration, and develop those permanent rules. And that will be over a several-month process that will be discussed during the board meeting with some, you'll have an example of what that's going to look like. I understand there's a question, so I'm almost ready. But that permanent rulemaking process is different than the temporary rulemaking process. There is going to be time on the agenda today to give feedback on the temporary rules that are in place. There's also going to be time to consider who you would like to have on your RAC and what that looks like in getting that permanent rulemaking started. And again, the background and underlying situation was to try to get something in place that people could be licensed on day one of this new year as required under the law. I'd love to have some questions.
All right, hi, this is Colleen. I was reminded that I need to introduce myself. Okay, perfect. Yes, so you said the temporary rules. I just want to be clear. Is that posted for everyone to see? And can you remind people where it has been posted? And can you also elaborate about the temporary rules, about what could be a criminal punishment? Mitch had shared about that earlier, that it was vague, that HLO might not be the full authority on that, and that there could be another organization that could enforce penalties. And so can you please elaborate on those 2 points so that we have a clear understanding of the expectations until June 8th?
This is Heather. Great question. So temporary rules are available to the public. They are rules. There has been notice provided. There was a communication that HLO sent out that had a link as to where you could get to the rules under the Secretary of State's website. I believe the rules are also posted on HLO's website. So if you go to the Sign Language Interpreters Board, on that page, you should be able to get to a copy of the rules and what's required. So there is notice to the public. They are out there for public consumption. We did not want to, HLO did not want to, nobody wanted to not have those available and not have people informed. So to get to that link, I don't have it at the top of my head, but Sammy could email it back out. Any person who needs a link to that could contact Sammy or Carrie via email and get that link. But again, they are on the website. They're also in the materials. So that is information available. The comment, if I'm remembering correctly, was in relation to criminal charges. So under the statute, HLO has jurisdiction over the regulatory part. So a licensee and a licensee who does commits a violation under the rules, or a licensee who does not meet the standards for qualification for licensure. So basically, there's the administrative side, the regulatory side of being licensed, and that's where HLO has jurisdiction. The law, the statutes also created that there is a criminal penalty for providing services without a license, and employing or contracting with someone without a license. That is not something that HLO has jurisdiction over. That's under the criminal side, which HLO is not involved in. So whether or not criminal enforcement is taken is not something HLO can have any impact decision-making on. Those are two separate things. HLO has taken the step of having a limited enforcement waiver, given the circumstances, understanding the bill required licensure as of January 1st, before the board could meet and have rules, and before people could possibly obtain a license. And so that limited enforcement waiver is something under their discretion under the law to do. They don't have discretion under criminal. And the rules do not address criminal law.
So just for my own clarification, HLO cannot penalize until June 8th. But for example, if a person does not have a license and the police is called on them, a complaint or grievance is filed, is it possible that that interpreter would be penalized criminally? And not just the police, but those of a higher authority. So what are the risks of punishment until June 8th?
This is Heather. So the risk of punishment is set forward in statute. And HLO has provided, as I said, we separate the administrative side, what HLO has jurisdiction over, versus a criminal side that HLO does not have jurisdiction over, and which I do not have the ability to provide advice on for individual circumstances. What I can tell you is that the law does state that there are criminal penalties for providing services without a license, and if a person wants to have more information on that, they should probably talk to an attorney or look at the law as to what it says. But in terms of the administrative side, and I understand that that's not a very comfortable answer, so I apologize that there's certain information I can provide to you as the attorney for HLO, the attorney for the board, and then getting into personal situations and circumstances. And criminal law is not something that I can do. HLO has taken the step under its discretion, under its authority to say for that circumstance in which a person is not licensed and providing sign language interpreter services, it will not take the action of imposing discipline for that. Okay. Now, if other things come up, if there are other potential violations, then HLO would investigate and look at that. For providing services without a license, that piece, there's the waiver on. Yeah. So HLO is trying to fill that gap, trying to do what it can, given the rock and the hard place that it's finding itself in, to try to make sure that there are interpretation services and that people feel that under the regulatory side, the administrative side for their licenses, that HLO has exercised discretion to not take action for providing services. HLO does not have authority for that criminal side. And I know that that is a concern. And again, that's something that HLO does not have the ability to change. And that's the way the law is written.
Hello, this is Alicia. And, I go by Al. As Mitch stated, we have some concerns about community responsibility. Interpreters who are providing services without license. So we need to notify HLO of that behavior, and then and if there is a practitioner who doesn't have a license, can the community file a grievance? Where is the community accountability there? I don't know if any of us on the board are familiar with the rules. Familiar with the rules and regulations in accordance to pursuing that process when we go through the police, or is there another avenue in which we would take action?
This is Heather. Thank you for that question. I think that that is something we'll be getting, the board will be getting more into as rulemaking happens and as the rules pertaining to discipline and what violations there might be come into play. Currently, if a person has a grievance against an interpreter, they can file a complaint with HLO. There may also be other places where the person could file the complaint, maybe with Foley or other entities. But they could file a complaint with HLO, and then it would go through the complaint process. The rules governing discipline and violations have not been addressed in HLO's temporary rules under the temporary licenses, again, because they were just getting licensing in place. And so that will really come in later in your permanent rules, when you're able to start having those discussions on what ethics code to adopt and discipline and more of those flush out those types of rules that pertain to the conduct of licensees and interpretation. Whereas, but a person can file a complaint with HLO. In terms of the criminal side, I don't know a lot about that process, but I would imagine that a person can file a complaint with the police if they chose to do so, and then what the police does with it, an investigation is up to the police in that criminal entity. Now, there may be some helpful information that Bob would like to share in terms of background and experience HLO has with other boards when there are criminal penalties. So let me pass it on to him.
Hi, this is Bob Bothwell. So I was the regulatory manager prior to being the interim director. And with all of our boards, all of our programs, there's most definitely, if not all, have a criminal penalty, for providing a service without a license. In most cases, law enforcement would contact us and ask if there's any conflicts or what's really going on. And in this case, we would share that we have the authority to have this limited waiver of enforcement, and we're not going to take any action. And in most most cases, not in every case, but in most cases, if HLO is not gonna take an action, law enforcement doesn't take an action. And if they did, it still has to go through the district attorney's office, and we need the same phone call. So I see that it's a huge concern for everybody, this criminal action. But, you know, I can't say never, but, you know, there's a process, and it's not as scary as it sounds.
Hi, this is Audrey again. I just wanted to clarify. RIC, the Rules Advisory Committee, are they the ones who set up the fee structure? And during the investigative process, where they're reviewing grievances against unlicensed interpreters, is the RIC involved in that process? And are they going to have any power to decide to pursue discipline against interpreters? I just want to know in case. I'm concerned how we as a board might have to get involved in that investigation process.
This is Heather. So that's a great question. The RAC does not get involved in who is not disciplined. The RAC is purely a committee set up to advise on rules, provide recommendations, provide their expertise on the rules. And those then recommendations and rules are then go through the board. And the board is the final say as to what rules get put in place. So the RAC, you know, maybe they would say, we recommend you put in this particular rule that would say a licensee should act in this particular way. And then it would come before the board, and the board would be able to listen to all of those comments made by the public, consider that rule, and decide whether or not to make a rule governing that particular conduct. So that's where the board comes in place. You get to hear those recommendations from the RAC and make your own decision as a board by vote as to what rules are put in place. A different separate process is when a complaint comes in and a person is investigated, and that then comes down to the board. A RAC is not involved in that at all. And the investigation is done by HLO. And then HLO provides the board with investigatory information that it obtains, you know, after interviewing witnesses, gathering records, looking at the situation, what happened, brings those facts to the board, and then the board gets to look at that. But that does not involve a RAC. I think that, you know, this is, there are so many new processes. This is such a different type of situation than being in a professional organization or being on a committee in a different field. So there are a lot of new processes to become familiar with, a lot of the ways things happen. So there's going to be just questions and confusion, and we really want to help and explain things to you and help you through that. So I'm glad for these questions, and you're going to have more questions. And while it may seem muddy right now, I think it will become more clear as certain things happen on the agenda and as more is explained as to what is possible with temporary rules, what is possible with permanent rules. And then much later, when after an investigation happens, when you walk through that contested case and disciplinary investigation process. And so please continue to ask questions. We'll try to address those as we can. And just know that I think everyone is information overload today, and working through and understanding all of these new government aspects. So that was my presentation on how to be an effective board member. Lots to think about, lots to remember. You're not going to remember it all today, but that's why we're here to help you. So continue to ask questions and we'll help you through that. And then as we roll through the agenda, some of this may make more sense and some of it may get more confusing. So thank you very much for your patience. Big break. 15 minutes.
You mentioned that one.
Oh, and lunch is here. And lunch is here.
Okay, it's approximately 12:45, and this is Bob, and we're calling the meeting back to order. I can see that everybody's here, so I'm gonna forego the roll call. We understand at the beginning of the meeting that there were some technical difficulties. We apologize. And up to a short time ago, we understood that some of the participants, the public, were not able to see the card captioning. And I wanted to let them know that they have to turn it on themselves. It's not something that HLO has control of. And Carrie, it works back here, who's running the show, has asked me to thank everybody for your patience with her getting this run. There you go. Okay, so now that we're back on the agenda, lunch is done. We have the Oregon Communication Plan.
Hi, this is Sammy again, and this is just, we've had some reports that people aren't aware of the new law and aware of the requirements. So I had to put this together for another organization. This is just to show you who we contacted, who we continue to contact with the needs and requirements. And then if you see someone missing from this list, then by all means, there'll be an opportunity in just a second to go over how we communicate with deaf people, how we communicate to interpreters, who we should be communicating to, what we should be communicating. Should it be in video? Should it be, where's the line? Kind of, how does your organizations do it? So these are things we don't know, and so now we're asking for your feedback on how your organizations do it, where your threshold is. I know we've heard a lot about doing a video, which Derek has done a lot of research on that and got some quotes, so we're ready to do it. Excuse me. But we don't know, is everything in a video? Is certain things in a video? Is there a criteria that we should be using? So just kind of giving us some feedback, because like we only know what we know, and I don't know a lot, so they're looking at me. So anything we can do to help get the word out there, if we're missing a group. I know the community's been really good about pushing the information out to other constituents that I maybe don't know about. So that's been very helpful. I know Office of Equity and Inclusion posted on their website, so people have been helping us, which I appreciate. But if you want to give me feedback on, let's start with videos. When do we do a video? Who is the video going to? And what would we put on video? So like the communication that we've been sending out, we know that that's an important one. So we've got a bid and we're working on getting that done. Always remember government is slow. So yeah, even getting Zoom in under 2 weeks was very quick. So, right, so things have happened very fast. They're doing a great job, but we just don't know. Does every application need to be done in a video? I don't know these things. Is it upon request? Is that how you guys get it in your organizations? On request. So you don't still have to answer me today, but be thinking about these things. You can put in emails. But again, we don't know what we don't know. we don't know what to ask, so we're just asking it all. And want to give you an opportunity to give feedback if you have any to give at this time.
Hi, this is Mish speaking. Thought occurred to me for general consideration. First, the law, then there's rules. And the website. They should all have ASL translation. And the complaint process and all proceedings should also have ASL translations and be accepted in ASL. There should not be a strict requirement to be monolingual in English. There should be an individual able to interpret or translate their complaints as needed. That's what came to mind as of now.
Thank you. I'll listen back if we have to call you for clarification. Is there anybody else that has anything in that area that they want to talk about? Otherwise, we can go to these.
Jack speaking. I have two things I wanted to share. One, in regards to having ASL accessibility, I suggest that you have a deaf interpreter or certified deaf interpreter to provide ASL accommodation for that, not a hearing interpreter. And the other thing I wanted to mention is an avenue to outreach to the community is you can contact Oregon Association for the Deaf. Currently, we have over 2,500 email subscribers to our list that we can share that information. That's one avenue I also wanted to share.
I'm not sure I understand. When do we have a deaf interpreter available? At what process? When?
Translator to translate.
In a meeting?
An interpreter to translate.
Oh, in a video.
In order for that answer to Holly. As she's a certified deaf interpreter, she can answer that. So would you automatically think that a hearing interpreter would be a better fit to provide the ASL accommodation, translation services? When in fact, it's better to have a native user. So although hearing interpreters may be professionally trained, they are not native users of American Sign Language. So in order to reach out to consumers who are native users of that language, who don't have to rely on a licensed professional hearing interpreter for that access, is better. And this is very rich in legalese. So it's better to convey that information from one native signer to another. As Jack just recently recommended, there could be a script prepared beforehand that could be on a prompt. Somebody could be feeding them that information as a team. There are many avenues to provide that accommodation. And when the need is there, then we can clarify with you in that moment. So then the next time you need someone for another situation, there would be an accommodation process already in place. That's typically how we function. We check what we need in that moment. Is there a script? And then the DI would go from there. Does that answer your question?
I'm still not sure in what scenario. Are we still talking about video? Okay.
So you were asking whether or not there should be a deaf interpreter for all video accessible information. The answer is yes.
Perfect.
Okay, great.
I'm not gonna mind if I show up in sweatpants and a sweatband tomorrow, do you?
I suggest you just get a second mic.
Okay. For those watching, we're discussing having a second mic since the interpreters and other participants are running around the room to make sure that there's microphone. So this is Tammy speaking. As has been mentioned about how to do outreach to various individuals and communities about licensure requirements, one of the problems that I have experienced and we have experienced previously is trying to connect with interpreters in educational settings in both Southern Oregon, and Eastern Oregon. So we are trying to create email lists, but it's challenging because we don't know where the interpreters are, what districts they're in, how to get in touch with those interpreters. So if someone could come up with a way to get in touch with rural interpreters to make them aware of licensure requirements, then we can try and work with HLO to make that happen. But currently I don't have an answer for how we can make that work. Hi, this is Audrey. So Tammy's idea, could we reach out to each educational service district? Could HLO be responsible for contacting all the educational service districts throughout the state so that they are made aware of the changes and the rules regarding the establishment of licensure? Tammy said, I've done that before, it hasn't worked. Because they don't know what they don't know. This is Tammy again. Sammy may have an answer. Would you like to answer, Sammy?
Yes, I've been working with Georgianne from the Department of Education, and she has been meeting with the service districts and getting the word out. That's who we were told to talk with. She has a legislative group she's working with and her attorney. So we are aware there isn't a list because that was the first thing we asked for. So she is working on getting something like that up and running, but we're aware of it. And we are collaboratively working with the Department of Education.
Tammy again. So previously with ORID, we established an educational interpreter group. And so we would reach out to the educational school districts, ESDs, in order to spread information about the services and supports that we provided to their interpreters. But from that point, the information was held and they were unsure what to do with it. We didn't know where to send it, who to contact, which school, where there were interpreters that were placed in those settings. That's the problem that we experienced in the past. So maybe Georgianne from Oregon Department of Education would have better information than we did.
This is Sammy. Yeah, I actually think Georgianne was brought on specifically because of this bill. I could be wrong about that, but this was like her first assignment, I can tell you that. So I know for sure she's been meeting with the different districts, and because they have said we are getting this information, and so they are getting it now that she's giving it to them. So
But if you know of other methods, mechanisms, tools, places we can, publications, we've done some press releases, we've done stuff in Oregon, some different publications through Oregon CCO's newsletter, we did that. So we're trying to get it out there, but kind of like, we only know what we know, and hopefully there will be people around getting information. So. Move on to these. So I did put the fee schedule in your packets. I will note that the original fee for education, the education license fee was $100 application fee and $150 license fee, and that we were able to get that reduced some because we are aware that that's a potentially a lower level job, so we were able to get that done. Thank you, Bob and I. Basically, how the fee structure works is it's really based on the amount of services that we get from HLO and the number of licensees that you have. So it was estimated we had around 400 or 300 licensees, and initially maybe 500 or 600 licenses, people versus paper. And then based on that, you just do math. So in midwives only have 100 of them. They have a $2,000 license. Cosmetology has 33,000. They have a $45 license. So you can kind of see the variation. So you guys are kind of towards in actually the lower end, really. So it actually went to the legislature, not in a bill, but in a fiscal analysis through 2696, and it listed out the fees. The legislature adopts them, approves them, and then HLO gets them. All HLO does is say, this is the service we're going to provide, and the community gives us the number that they think is going to be licensed, and then it's just a mathematical assumption. It's not for sure, it's just like, we thought there was going to be 1,500 advanced estheticians, and there's 300. So, I mean, it's all an estimate. But that's kind of how the fee structure works here. I'm happy to answer any questions or Bob is. It's more history number 9.
Can you repeat that last part with the numbers? You thought there was going to be.
Oh, advanced estheticians, we thought, well, we were told there would be 1,500 of them, and there's really 300. So they were basing it off of basic estheticians, there's 15,000 of that, but it didn't end up being that many. It was one.
This is Tammy again. My first question is, well, how long does the license stay in effect for? 2 years, 3 years? 1 year? 1 year, okay. Most educational interpreters, well, I would say many of them around the state earn less than $18 an hour. They work 192 days a year. And I would say many are on food stamps. And if they have to pay $175 every year, I just don't think that's going to be possible. They might go to work for Starbucks instead, or somewhere else they can earn more money. And that is going to affect our students who need those services. And I don't, that's not acceptable.
100. 100. One time application.
There's an application fee. Oh, it's a one-time application fee.
It's the renewal that's annually.
Okay. Okay, that's better. But still, it'll be difficult for many. we're already struggling to find people who are willing to work for such low pay to begin with. And to add this extra annual fee is gonna make it even harder. Especially in rural areas around the state, who are barely able to find qualified interpreters as it is. So just something to think about. I mean, I don't know if we can change the fee schedule, maybe to $75. I think that would be easier and more manageable for many educational interpreters. And the interpreters wants to clarify, for some, 75 might sound like nothing, but for educational interpreters, it's actually quite a lot. And then this is Colleen, I'd like to add, Tammy, thank you so much. Yes, it's a very sensitive subject. Are you aware that we have to pay for our other credentials as well? We also have annual CEUs. And I don't have a total for you now, but just to stay credentialed in this profession is incredibly expensive. I think I told you earlier, I have 14, 15, 16 different licenses that I hold in various states. And I won't tell you which state, but I'll tell you the numbers. I'll show you some of them. So $0, $7, $95, $175, $75, $35, $40, $100, $225, $200, $125, $120, and $60. Those are different various license fees that I have to pay. All those are annual except for two that are every 3 years, every 5 years. And the $225 one is for 3 years. So if you think that $300 for 1 year is small change, it's embarrassing because it's a lot. The chair has wheels. Oh, the other chair has wheels, this one doesn't. You also have to look at the different licenses. For supervisory, it's 100 to 200. But then you have to add medical, legal, educational. I personally have 4 different licenses. I have provisional licenses. You know, but if I'm looking at all of them, that'll be $300 to $500. I don't want to complain, but I looked at the legal interpreter fee and it's $50. And they're paid $125 an hour compared to educational interpreters who are paid $16, $17, $18, $20 an hour. And they have to pay more for their license. They also have to pay for the supervisory license, the mentorship. And so that, to me, is a disadvantage. It's going to be very challenging for those rural interpreters. And it could also impact the availability of interpreters for those areas. And I'm Eric, by the way. Thank you for the reminder, says. I tend to forget to introduce myself. This is Michelle speaking. Hi. Thank you so much for your comment. Every comment that's been said here so far, I agree with. I would like to ask HLO to consider coming up with some new math, new calculations. So you said for 300 people and 400 licenses. If you're looking at the numbers now, the numbers have changed. The numbers say 400 medical interpreters, which means that's an automatic 800 licenses, just for those who specialize in medical interpreting. I know that there are so many more interpreters all over the state who are not just doing medical, but the math that we had seen before is incorrect. And so I'm wondering if we can do a recalculation with more accurate numbers to come up with a better, more acceptable rate. Thank you for your consideration. Hi, everyone, this is Audrey. I agree with Mitch. I think, if we look at the numbers for provisional license so far, our prediction is that, those numbers will only increase for actual licenses provided. It's a dynamic process. As the numbers change, we'll change. We can change the fee structure as well. Instead of just having a rigid fee schedule set in the beginning, I think it has to be dynamic. Is that possible?
Government's not dynamic. It takes a lot of time, so we have to go back to the legislature. All these things have to happen. But I mean, I think we're gonna walk away and see what we can do, for sure. I mean, it's not the end of the conversation. I thought. Nope.
This is Bob Boswell. I'm gonna read us into executive session now. Board of Sign Language Interpreters will now meet in executive session pursuant to ORS 192.660 subsection 2F, ORS 192.355 subsection 9A, ORS 40.225 for the purpose of considering information exempt from public disclosure at 1:11 p.m. On January 3, 2024, representatives of the news media shall be allowed to attend executive session. The public will now be moved into a separate breakout room for the duration of executive session. Please continue to keep your phone and cameras off. Are there any representatives of the news media on Zoom? If there are, please raise your hand. There's none.
Nope.
Recognizing there's no news media in attendance, the public will move into a separate breakout room for the duration of the executive session. We will return upon open session before taking any final action or making any final decisions. It is estimated that the board will return to public session at 1:30 p.m. Please be aware that it is possible that the board's executive session may last longer than 1:30 p.m. If the public has any questions about whether the board is still in executive session, then the public can contact Carrie Edwards at carrie.edwards@oha.oregon.gov. We are now in executive session.
The card services on during this portion?
Do you leave them on? You probably have them on.
Just as a backup accessibility. That was available.
I'm not sure who can see the card captioning. If anyone outside of the executive session can see card captioning, they would be able to keep it. But if it's separate, they can't. And if that would be helpful for a future executive session, please let us know so that we can make that happen. Again, we want to make sure we're doing what we need to do to have the best communication possible and hearing your feedback on this.
If it's just a short breakout, that's fine, but if it's an all-day executive meeting, then I prefer to have.
Thank you. I want to confirm with HOO that the only people in the executive session on Zoom are the people that should be, are all the Zoom participants out of the executive session?
There's some that aren't named, so I'm trying to figure that out on the side over here.
It's not, I don't know if she's in.
Oh, I know you.
I haven't assigned rooms yet. I'm just,
Probably still looking at.
yeah, I'm still trying to assign rooms, so.
So logistics are that we are, Carrie is moving people into the correct room so that we'll be able to have the private executive session. So we'll hold off on discussions until that is done.
I'm just trying to make sure everybody is admitted as well.
Can we put the ASL interpreter for our screening?
Oh.
Asking, can I change that on this laptop? Okay.
Because right now it's Nathan's name. is on there.
Yeah.
Makes it easier for people to find interpreter.
Got it.
Interpreter, they're listed as-
They don't
know who made this? The name's not even there.
Some of the mask. That's a good catch. I didn't see that before. It was. Oh, stop it.
This is Paul Walpole. The Board of Sign Language Interpreters will now exit executive session and reconvene open session at 2:02 PM. No final decisions were made and no votes were taken in executive session. The public will be moved back from the breakout room and representatives of the media may once again report all board discussions and actions. And then we are going to take a 10-minute break before. We will be back at 13.
Try and talk into the mic.
This is Bob.
Because it should be coming out from up
It
there
is.
for the actual speakers, so.
And we're gonna move on to item 8 on the agenda, which is approval of the 2024 chair and vice chair.
So,
We are recording today.
So this is, the nominations committee, in your law, it says that the board must elect, not elect. Select the chair and the vice chair. And you can determine the terms of office that they serve and any of the duties that they perform. I will say that in when we do rules, I will present kind of standard boilerplate language that we give when anytime there's a law in place that says that the board needs to have a chair and vice chair, sometimes they don't always have vice chair. And then you guys can play around with that, things, all of that. But in this circumstance, you can nominate, or one person can nominate themselves, someone else can nominate them. And you can vote on them all at the same time. Or first the chair and then the vice chair, it's really up to you as how you want to roll it out. What works best for you. Just start with chair.
Repeat that very quickly. I nominate Jack Ludwig for chair. This is Jack speaking. I would like to make a comment for figuring out logistics. This is Jack speaking. Before I accept, I did have a couple questions about the responsibilities of the chair. Am I allowed to ask that? So I would love to be the chair, so basically I accept, yes. My only concern is, as the chair, does that mean that I lose my voting privileges on the board? Because as a deaf person, it kind of means that then I lose my voice. And there would be an imbalance between the hearing board members and the deaf board members. So my question is, as the chair, would I be able to vote? I understand that my responsibilities would include running a meeting, developing an agenda, moderating a meeting, and so forth.
Voting will be absolutely yes, you will vote.
Voting will be yes, absolutely, you vote. In that case, then I accept your nomination.
Can't make a motion.
Can't make a motion. She's repeating.
I did want to add on to that, so is it an exception, so I can only vote to break a tie, or am I part of the vote process regardless?
Regardless.
Great.
Were there, this is Bob, were there any other candidates for chair?
Tammy,
This is Tammy, and I would like to nominate Colleen.
Then for chair or vice chair?
For chair. I'm trying to remember my own name. This is Colleen. I'm awful with that. So, great, thank you. I don't accept that nomination. I have too many things on my plate currently, but maybe I'll accept another role, wink, wink.
this is Bob. Do we want to?
Are we nominating for chair and vice chair right now, both?
Yeah.
Colleen's laughing. This is Tammy. So I would like to nominate Colleen for vice chair. Just sign, it's up to you. A lot of up to yous around the room. Colleen, here. As long as the hearing interpreters don't feel like they're not included with this vote, then I would accept the position, but I don't want to step on any toes, hurt any feelings. Full support. All right.
So we need a second.
I second. This is Eric. I second.
Okay. So I will, I'll handle this for Jack this time. Next time it's on me. Motion has been made and seconded. Now we'll call, or for to make, excuse me, to make Jack the chair and Colleen the vice chair. And now we'll take roll. Colleen. Give your name.
Yes, yes, I.
Al.
I'm voting for them, aye, yes, I'll vote. Jackson, aye.
Jack. Okay. Audrey,
Yay.
Nish,
Support.
Tammy,
Yes.
Eric. Motion carries. Thank you, everybody.
Thank you. You want to give Jack the mic? Give him stuff?
Yeah, this Jack on the table.
I don't know.
Until tomorrow.
So, we're just gonna move on to the next topic.
Yes.
And so it's, apologize that there should be an issue statement in place of this, but there is not. There's not. So what do you have as a rule? Extenuating circumstance rule, basically, saying that individuals, so I'll just read it. An individual who holds a temporary license under the HLO rules 331-050-0020-20130 is not required to be otherwise licensed under HB 2696-2023 until June 8th, 2024, or until granted or denied a license under rules the state board implementing 2696 sections 2 and 7. So, this is just saying, basically saying that the temporary license that HLO is now giving is good to be used in place of that has with 2696. The license is 2% until June. So, and it's just, it just basically says that it's an extenuating circumstance because the operative date of the bill was January 1st. The board couldn't start reading until January 1st. The board's in charge of rulemaking. They couldn't meet until January 1st to make sure that there was interpreters in place to be licensed. HLO put this temporary rule in place,
And there's extenuating circumstances. That's the extenuating circumstance. And so except for your guys' discussion about the rule here in your packet at the end towards the very end.
So Mitch has comments.
Because of the extenuating circumstance, I propose to establish a temporary license until June 8th. Was there a question? I'm moving to approve this. Yeah, I motion to approve this. Okay. Sorry, I said the wrong thing. I motion to approve, not to establish. I'm learning.
Thank you, Mitch. And we need a second. And Colleen seconded. Motion has been made and seconded. I will do roll call. Excuse me. Jack? Audrey?
Aye.
Al? Mish? Colleen? Tammy? And Eric? Motion passes. Okay. So the next item on the agenda is public interested party feedback. We have. Are there any comments? And I need to read this one too. So at this time, the Sign Language Interpreters Board will now hear public interested parties' feedback. Members of the public, please wait until you have been recognized. Once recognized, please state your name and affiliation to the board for the record. Sarah Camerford.
Hello. My name is Sarah Comerford. Thank you for allowing me to provide my comments in spoken English with my camera off to preserve my bandwidth, coming to you on a laptop today over Wi-Fi.
They should be able to unmute. Okay, she might be wanting to sign or.
Are you not able to hear me?
So this person unmuted, yeah. Yeah, she's not. She's trying. She just has to turn on her video. I mean, I can turn it on. So tell her.
Are you able to hear me?
Sarah, if you can hear me, can you turn your camera on?
I asked her to turn it on.
My camera is on, but my bandwidth is not great because I'm on Wi-Fi.
Oh.
Camera needs to be off.
Hi, Sarah.
Can you hear me?
We cannot hear you if you're speaking.
You need to be able to hear me.
We can see you if you're going to sign.
Hi,
I am not signing.
hi, Sarah. This is Trampus from HLO. I'm going to walk into the boardroom and let them know what you're trying to say. Okay.
It's must be something with her audio.
Oh, you are?
Yeah, she can't, use her camera because of bandwidth issues. She wants to be able to speak and then, spoken English.
Okay, Sarah, okay, so your camera's off. Can you try saying something now?
My microphone is unmuted. Are you
So
able
you're
to hear
trying to
me
say
in the
something that's not
boardroom?
coming through.
Here, line it says.
Stand by, Sarah.
Then it comes to this. Say something now? The chat off. We have to-
Oh, can you see what card is put up on your screen, Sam? Can you see what card is put up on the screen? She's.
I didn't log in. Because they wanted me to do an audio and that's afraid it was yell.
So we're having bandwidth issues here too.
Have her try and say something now.
Sarah, can you try and say something now, please?
Testing, are you able to hear my audio in the boardroom?
Hi, Sarah, we got you. Thank you. Thank you
Oh,
for-
lovely. Good afternoon. Thank you so much for going through that little sojourn and able for me to be able to provide my comments in spoken English today and allow my esteemed colleague to interpret for me. I'm camera off because I'm coming to you over a laptop through Wi-Fi. And I want to make sure that my comments are as accessible as possible. My name is Sarah Cumberford, they, them pronouns. If I were on camera, you would see a mid-30s femme non-binary person with short brown hair, glasses, red lipstick, and a light complexion. I'm here today representing Oregon's Registry of Interpreters for the Deaf, our board, and our membership of roughly 75 members, interpreters, and organizations. From consulting with past presidents, other ORID leaders, and the community, the board understands that the intentions behind the licensure bill and our organization's historical support of the legislation under the realities of implementation may no longer align. In order to represent our membership accurately, as well as meet our stated mandate to promote collegiality within the interpreting community of Oregon, we believe it is imperative that we proceed with transparency. So I will speak to the observations that the board and the membership have made thus far. First, I want to acknowledge the pain points members have already experienced due to the inefficiencies in communication, flow of information, and general lack of knowledge regarding the licensure process. Our board of volunteers are also working interpreters in the community, but even with the privilege of some advanced knowledge, we felt the same fear that our members described when certain questions about their livelihood went unanswered. We heard them when they said it was an act of unfair gatekeeping to release information via Facebook, and we wished that we had had the resources to do better. I want to echo some of the comments already made by staff and board members today during the meeting. This process is both emerging and evolving, and it requires all of our grace. In the future, I hope the SLI board and whomever partners with ORID to help us maintain an informed, engaged, and eventually licensed membership is prepared to collaborate in that same spirit of grace for this working class group of professionals. Indeed, that is how our community has responded, by crowdsourcing information, sharing links in the comments section, and by offering each other moral support. To be clear, however, it is not the board of ORID's position to adopt a role as liaison between the state board and our membership. We understand, though, that with the organization's past involvement in drafting the legislation, plus emails naming, quote, an ORID representative, unquote, on the SLI board, were legitimate causes for confusion. And indeed, some of these questions still remain. How did the selection of an ORID representative on the board happen? Who was consulted in making that decision? And is that decision still current? The Board of ORID will continue to encourage our membership to be an active voice for what they collectively and individually wish to see from their licensure board. And we look forward to working closely with the licensure board in whatever capacity the membership calls for. That concludes my comments. Thank you.
Okay, next up is Adam Logan.
Can he raise his hand, please? Because when he raised his hand. I don't see him on here anymore. It's no. I don't see him on here anymore.
Okay, we don't see Adam. Tara Smith.
I don't see her either.
This is Tara Smith. I do not have a public comment at this time.
Thank you, Tara. And then we had someone who was anonymous,
Sandy has the email.
and it is
No.
Mel DeLeon.
Hi, this is Mel DeLeon.
Hi, Mel, we can barely hear you.
Can you hear me now? Is that better?
Perfect, thank you.
Thank you. My name is Melanie DeLeon. I work at Portland Community College as their ASL interpreter and transcriber coordinator. I want to say thank you and applaud the work that it has taken to get us this far, and also acknowledge at the same time the growing pains that has been echoed earlier today. I too have heard the fear and the confusion, and we're all learning in this process. I wanted to clarify some misinformation I heard. I am one of a handful of legal interpreters in the state of Oregon that hold the ASL Oregon Court Certified Credential to interpret in the courts. We make $74 an hour. I just wanted to clarify that. On the point of renewal for our license, I wanted to recommend moving it to every 2 years, or at least ask the board to consider aligning all the different licensures and their renewal time cycles. Between being a legally certified interpreter with the judicial department, having my Oregon healthcare medical license, and now this, they're all on different timelines. There's a lot to manage. Somehow aligning all of these processes and being cognizant of them all would be helpful and show support to the community and understanding of the wide variety of settings we find ourselves in. That's all I have to say. Thank you.
Thank you very much. Okay, thank you, everybody. This is Bob Bothwell again. We have an email that they would like, someone would like us to read. It is public comment. What it says is they would like to remain anonymous due to fear or potential retaliation. And then it goes on to say regarding the Ludwig's personal financial gain and conflict of interest. Jack Ludwig is on the board and is married to Chad Ludwig. One of the requirements for OHA and now HLO for a medical license, the NSLA, that Bridges Oregon facilitates. Bridges Oregon is a nonprofit which Chad Ludwig is the CEO and provider of required NSLA tests. Although there are other approved NSLA providers, Bridges Oregon is the largest and most prominent in the area. 388 NSLA this year, each in the cost range of $185 to $220, depending on the applicant's choice of with feedback or without feedback. That would be a total of 71,780 at median minimum. For processing assessments in 2023, I believe they also charge an additional processing fee of $5 per assessment, potentially raising that to $73,720. Chad Ludwig is also active on the OHA board, and Jack has testified at OHA board meetings in support of this amendment to the OHA rules. What will HLO do to ensure that there is no conflict of interest, HLO and the Ludwig's employment and business financial gain? Can HLO please investigate this matter further in additional to providing this public comment during the meeting? That was all. So you want to enforce instruction about public. Okay, moving on.
Right on. Okay, so the next thing on the agenda, this is Sammy. No more public comment?
Looks like there's somebody in the waiting room.
Someone's in the waiting room.
So I just had a question. This is Eric. I don't think it's regarding public comment though.
Yeah. So next on the agenda is just time to get some feedback from the board in relation to moving forward with rulemaking and are we on the right track with temporary rules? Does there need to be higher standard, lower standard? I do have some, so kind of the biggest concerns we received are people who hold, who are on the registry, the healthcare registry, often don't qualify for the medical endorsement because they don't qualify for a supervisor or generalist license. That is in the statute. So that they have to hold the generalist and the supervisor to get the medical. If you could lower the standards for generalist or supervisor to bring that them more in line with the medical, that could get you a license. There are all kinds of options. You can do better. So just kind of give me some feedback. I'm trying to find the rules here. We start with the general license. The other thing that I have heard is people who are born deaf. I think they're back in the COVA. Is that right?
That's a child of a deaf adult. So they're here.
But they don't qualify for numerous reasons. I'm assuming because they don't have formalized training, that's kind of what they allude to here. I don't know. So if we just start with, so the general administration is pretty much picked up from the statute. It's holding a license under these rules do not guarantee The license holder was granted a license under the board. That's important too, right? Because HO has a license, but the board may go, nope, we want you to have a higher standard. And if they don't meet that standard, they won't qualify for that board license. Clear, I want that to be clear. May not be the same, so may not qualify. We'll see. And then the rest is just reiterating what's in the law. But for, yes. Next one is supervisor license, so it just goes, basically we have everybody attesting to everything. The only thing you have to do is fill out the application and send us the front and back of your ID. Two forms of ID, one has to be photographic, the front and back. That's where people are not sending back the front and back of the ID, so Michael's calling saying, we need this, they're sending it, and they're getting one. However, if you don't meet a standard on the list, you're not gonna qualify for the license. So qualification versus denial are different. You just don't qualify because you don't meet any of these requirements. So you don't qualify. Doesn't mean you're being denied, just says don't qualify. Are these the list, right? Is this the correct list? Yes. Big five.
So, this is Eric.
Yes.
One of the things I noticed in under the general is that it lists a lot of the sunset or older RID certifications. But one that is lacking from there is the RID at K-12, which was recognized as a national level certification for 2016. And that's actually, that comes up later in the medical as well. But in this one, at the very end, it says EIPA secondary level PSE 4.0, EIPA secondary level ASL 4.0. With the EIPA test, there's two portions that you can take. You can take the primary or you can take the secondary. And up until this paperwork, it was never differentiated whether you took one test or the other. You would be nationally recognized whether you took primary or secondary. And so I specifically, in my region, have one interpreter who has taken the primary and scored a 4.0 or above. And because they have a national certification, OHA recognized them as a nationally certified interpreter and they have a medical license. But now that this stipulates it has to be a secondary level, it eliminates that person from being eligible for the license because they took the primary level test. So I think if we could expand that to say just EIPA 4.0 or above, and it doesn't have to stipulate whether it's a primary or secondary, I think that might be more inclusive. And then also, and are we jumping from each, are we staying?
I can do whatever you want. Any comments on that before you go?
This is Tammy. So the EIPA and the NK-12 it's a hot topic. They have put a moratorium on the NK-12 because the issue being that RID recognized the EIPA and allowed people to have their NK-12 recognition through RID, but they were not considered a nationally certified interpreter because the EIPA is not a certification test, it's a qualification test. Again, mincing words. And so there was some, pardon? So there was some discussion about it. So RID has paused that situation currently. So whether that's nationally recognized or not is an issue that we would need to discuss. There's something else I was gonna say, and I can't remember now. It'll come back.
Did you say the qualification test?
It is a qualification test. It's a test of skills.
It's an assessment. It's
Yes,
not a test.
assessment.
Assessment.
Thank you for that word. I should add the word assessment.
Hi, this is Mish. I'd like to add about the EIPA primary and secondary levels. I did reach out to the EIPA and do a little research to find the difference, and it looks like they use the same assessment for both levels. Use the same video, but then it's the same assessment for both levels. They use the same video of qualifications and skills. And so if you remove, they just remove the secondary and you'll have the primary. So I'm in support of that, removing the language of secondary level and leaving it otherwise as is. And this is Tammy. Following Mrs. comment, that matches the OARs for K-12 interpreting as well. They don't distinguish between primary and secondary. They just say yeah, they do not stipulate a level. They just say you qualify or not. And so our language, if we remove secondary, add just one word, then it would, in essence, match the OARs that are currently in place.
What OARs? What OARs? Healthcare?
Related to educational interpreting.
Okay.
So, yes. Sam says, oh, okay.
We actually wrote this. You gotta recall. Never mind. Never mind.
So I understand that currently we're discussing whether or not it's a supervisory or general license, not the educational license. But if we wanted to have a standard for all, and that would be in accordance with the educational language that's used with all of the other language with the licenses, then that would create a standard.
Sorry, I will say this, that the bill does require.
The bill does require that we collaborate with the Department of Education. Because these are HLO rules, we don't have to, we're not following what's in the bill, because we don't have that authority. So when we start to write the board rules, we will be collaborating with ODE, and I believe they'll align. They should be the same, this is my understanding. What they have and what you have should be the same. Who's gonna have it first? I don't know. That's debatable at this point, so. But me and Georgianne are talking and working through what that requirement is. 'Cause my understanding, to get that test graded takes some time, and which could put licensing on hold for people, I think.
I don't know if there's a lot of options.
Okay, I'm not communicating well in my second language, so I'm gonna stay in my first language. So aligning the language with the OARs by eliminating the elementary or the secondary level, we should do. The OARs, however, in Oregon currently only require a 3.5, not a 4. So if we want to keep the EIPA for the generalist or the supervisory, I think the 4.0 is more in alignment with what would pass for an RAD certification. So we would need to keep the 4.0, just get rid of the secondary.
You want to say EIPA level PSE 4.0 or above.
Yes.
Or
Yes.
ASL is the next.
Yes. So the language would read EIPA, to repeat what Sandy said, the language would read EIPA level, EIPA PSE 4.0 or above, or EIPA ASL 4.0 or above, and eliminate the secondary level. And to answer your question about the length of time it's taking to get results for any of the certifications in our field, it takes months. 4 or 5 or 6 months too, which is some of the concern with the temporary licensure that people are having with getting licensure at all and finding out for some people at the very last minute that they needed the licensure when it's going to take them months to get their certification. Are we still just talking about generalists and supervisor at this point?
Yes.
Oh, my question.
I mean, we can move on because I can go back and forth.
Saying that the deaf board members are not able to keep up because the pace of conversation is moving too quickly. So we please have more time for turn taking so that we can participate. Would you like us to? Colleen says no. I can follow the conversation. This is Colleen. I can follow the conversation, but my main concern is that when you're talking about removing certain language, it takes me a moment to find where exactly you're referring that. So please give a page number. I know that, we just got a second handout, but the three of us are visually listening. Jack understands what I'm talking about. And so I had to take the physical effort of getting up and walking over to see where we were, so I didn't have to interrupt, and then I could inform my colleagues adjacent to me where we were. So if you could just please share the page number where you are on the page, then we have a visual connection. And Jack is adding on, if you could please clarify which line you're talking about from now on. That's all I was asking. Just so that we have that visual connection to what is being discussed and what we're looking at on paper. Hi, this is Audrey. This is not in reference to the general license or the specific language, but it does not share what educational settings you would be working in. Is it higher ed or K through 12? It seems like we're focusing on K through 12, but often many of us work in higher ed settings. So I'm just thinking, is this K through 12 or is this in higher ed? So I just want to clarify the difference between those two before we continue the discussion about that particular license.
Is that, education starts like 0 to 3, 5, so it's not only K to 12, it's also like younger than that too, so we need to consider all of those areas.
Specifically in the HLO rules, it's
Sorry,
defined
French toast? Yeah.
under H1.
You want to hold on to this, so I'm gonna clear it? I think I'm gonna,
on
get
page,
to go, yeah. All right. No problem, thank you.
Rule number 3, education setting needs a public agency or school district. And those terms defined simply are by the 1/01/2000, which is Department of Education. That's
And then, and the bill specifically, goes to the Department of Education. So
I think what we came to was that the education is around K-12. And the higher it would be a generalist or a supervisor.
is that clear? Or even more clear, I guess.
Better. I can write that down.
Typically be repeated later if it's.
This is Tammy. So my question is would it typically be repeated later in the rules if it's stated at the very beginning? Would it also be repeated later in the rules and made more clear that this is specifically K-12?
Usually if you define it up front, you don't say it again, but you can. There's nothing saying that you can't. So if it's more clear for people to repeat it every time, absolutely.
I will just add that I think public agency caused me some confusion because a public university or college, I could see being interpreted as a public agency.
Interpreter search.
Yes, we can look for some different terminology. I think we pulled that as a law number somewhere, but I have to verify that. There's other language. Do you think we need to make it clear that it's K through 12 only, or that it's not higher ed or both?
I think the more clarity, the better. Specifically, if we specify it's for K-12 only, does that mean, does that also include transition services? They're technically within the school district that are covered. You know, because school district services can look very different, right? From the kindergarten level to the 12th grade level, do you know what I mean? And so if we specify the time frame and we say K-12 interpreters, I don't know, what do you all think? As a board, and what does the public think? Audrey, this is Colleen. I feel like that's a good point. You know, if they're providing any services at the Department of Education, can we just say Department of Educational setting? You know, that would include the deaf schools, that would include the ESDs, that would include transition programs, that would include preschool, pre-K services, that would include everything. We said just under the purview of ODE. So, or a Department of Education where services are provided therein, where you don't specify an age or a grade level, would create a larger umbrella. What do you think? Jack is saying entities that provide services, school-related services for students. And parents, we'd have to say parents as well. Sammy, are you following this?
The parent part.
Students and families, maybe students and families instead of parents. Yeah, for example, I am a mother, I'm deaf, but my children are hearing, and so I go to teacher-parent conferences. And so the interpreter would be there for me as a parent, and I would be at a public school receiving interpreting services. So what license would they have?
I mean, depends on the service being provided.
Good question.
I have to look at the Department of Education.
So if we make the language a little bit more vague, so providing services in an educational setting. But it already says that, Tammy said. Right, but not limiting it to K-12. All right, well, I will close my hands.
Okay. Is there anything anything else under supervisory? Generalists, they're the same, except supervisory needs 3 years of experience. Or full, the license.
Hello, everyone. I know you're loving me being up here. This is Colleen. So what was HLO's decision on having to break down their fees for each, generalist, supervisory, with the additional licenses? Can we possibly consider the fee for medical and legal encompassed in other licenses? So you don't have to pay fees for each one. So for myself, I had to fill out 3 separate applications, which I felt like was ridiculous. If I could fill out one and just check a box, which I do for other states, that would take care of it. There's one application instead of having the 3 separate applications for each license. And so the specialties could be all listed on that initial application, the one application. So if you are filing for a supervisory license, then you can check, I would also like to add medical, legal, or whatever it may be, instead of having it as a separate application for each.
I think there's 2 questions. The first question is, do you not want to fill out 3 applications? Or do you not want to pay 3 fees? Or both? If you don't want to pay 3 fees, you probably got to go back to the legislature and tell them that. And they do a combined license. If you don't want to fill out 3 applications, that's something HLO. We can combine them. I'm sure Kelly's either in the room or listening somewhere. In the room. She will go, I wanted to do that in the first place. Yeah. So those are kind of 2 options that you have. But you will pay all 3 fees.
Yeah, get a second mic for that too. I just had a question for the supervisory license, and mentoring. Somebody's a mentor, do they have to have a supervisory license? Be a mentor.
sorry, but I don't feel like the answer was good enough. We have to pay 3, we'll have 1 application, but pay all 3 fees. I think that shouldn't be the case. I just asked my colleague, because we both have legal specialties. And there are maybe, what, 7 or 8 of us in the whole state of Oregon? That's it? Yeah, so 8 for the entire state of Oregon who are specialized in legal interpreting. Because that certification is no longer offered, which is another topic. But I have to pay another state fee for holding my certification with them. And so I feel that since I'm paying for the courts to hold my certification, I also have to pay for this. So I'm having to pay double for my certification now. And then she's saying, what can I add to that? So this is going to challenge me. It's not really a problem, but hold on just 1 second.
Somebody has to leave at 3:45.
The caption for okay, so apparently the cart captioner left.
3:45.
And the cart,
We only had the
Captioner
meeting
leave?
scheduled till 3, so the cart captioner was only scheduled till 3.
okay. The cart services had to leave. Because it's after 3. Is the meeting adjourned?
Yeah, we can
Call me
continue
now.
tomorrow because we added on the agenda that anything from today can go on to tomorrow. We can start right back at the top. So we're holding the discussion? Yes.
Okay, this is Bob. So the sign language interpreter board meeting is adjourned at 3:12.
I have a question.